All right, folks. So we're now in the final run here of the symposium. We're going to chat with you for a little bit of time, and then we'll have the reception. Um, we've covered a lot of ground today, and you've heard what I've heard in terms of what our outstanding speakers have addressed, as we've talked about, what is a court-appointed neutral, or some would say can, the Swiss Army knife, and next to me is the father of the Swiss Army knife, Merril Hirsh. The ethics of serving as a court-appointed neutral. We all received comfort from Dennis as he assured us that there is complete clarity in the rules and the expectations. But on a more serious note, really, we benefited from the great guidance from that panel as well, as they did, I thought, an outstanding job taking a look at the rules, codes of conduct, related codes of conduct in connection with mediators and arbitrators. And this is some of what we've been touching on during the last decade or so as we've been exploring the potential rules of ethics that apply to court-appointed neutrals and what we can do to try to help clarify. Certainly, again, a wonderful inspiration address from Justice Kennedy, talking about the importance of language and the importance of leading, the importance of mentoring, and the great personal story that she shared. Of course, getting judges on a panel, always a terrific draw, and I think today was no exception with the panel after lunch. We have to encourage, I think, Judge Stong to bring a little more energy to her presentations, but other than that, but no, she's a dear and longtime friend. We actually met when she was a senior associate at Wilkie, and we spent at least one or two nights working through the night together on a corporate hostile takeover case in Delaware. And then, of course, I was just so delighted when she joined the bankruptcy bench, and she's been an outstanding leader in the ABA business law section and beyond. So we were really, truly blessed to have her, but also Judges Driscoll and Szilagyi. And Ed, I asked Ed if he would like to join yet another panel today. Ed, thank you so much. And Kathleen, thank you for your role on that panel. And Kathleen, very importantly, it's in her bio in the program, but she chaired a model rule subcommittee within the Court-Appointed Neutrals Committee. Merril might touch on that. That was a very significant undertaking and resulted in a very important action by the ABA House of Delegates adopting the model state rule as a parallel to the federal rule of procedure 53. And with the ABA House of Delegates, for anyone who's not familiar with that group, the ABA president, for example, can only speak to policy that is adopted by the ABA House of Delegates. And so when something like a model rule is adopted, it's extraordinarily important. Likewise, when something like guidelines addressing, and at that time they did address special masters, were adopted by the House of Delegates, that was very significant. And I think Merril will probably touch on that, as well as some other more recent activity before the ABA House of Delegates. And then, of course, we just heard about teaching ADR and what are the real world opportunities. We did get the contrarian view from Professor Phillips and his co-panelists that teaching ADR really does make a difference, and in fact can present real world opportunities. Thought it was so interesting to hear about the evolution of the ADR curriculum through the years. And at least from my perspective, and maybe many of us in the room shared this in law school, the focus largely was on developing litigation skills. And so even in the first year, of course, civil procedure, criminal procedure, at least when I was in school, a first-year moot court competition, and then moot court teams that you could vie to join, national moot court, international moot court, and so forth going forward. There may have been a negotiations a competition, but very, very nascent at that time. But otherwise, the curriculum highlighted things like evidence. There were trial practice competitions and clinics. And fast forward to many years later, in practice for me, as I was getting more and more involved with mediation work as an advocate for clients in mediation, I was running into a school of thought to the effect that actually some of the most effective lawyer mediators, advocates in mediation, were not litigators, but they were transactional attorneys. And they were transactional attorneys because, at least the best ones, knew how to get to yes. They were not going to come in and just sort of import into the mediation setting litigation skills, which, for better or worse, sometimes could, reflect bomb throwing. And so, at least I think what I was hearing from the last panel, including Professor Franklin, was this idea of the importance of really understanding the transactional side, and to Professor Phillips' point, the key critical importance of skills and negotiations, no matter what the substantive area is. And as a mediator, I've certainly seen that the process has benefited from counsel who really do understand it's important to get the yes, including sometimes insurance counsel. So that's sort of my very brief takeaway from the topics we've covered today. I think it's fair to say we've probably scratched the surface. We knew that we could only cover so much in one day. We also held our breath a little bit in committing folks to a full day because we didn't want to presume. We know everyone's busy, and your time is precious. And so we're really very grateful for the time that everyone's taken to attend either in person or remotely today. And certainly so grateful to all of the speakers, to the law school, to our wonderful AV team back in the corner this morning and this afternoon. Thank you, folks. Again, Professor Phillips, Rose White, who has always done a wonderful job. And then the law school is just so professional every step of the way in presenting, organizing and presenting one of these programs, from the marketing folks, communications, catering, and we are just very appreciative. Most of all, I want to again turn to the father of the Swiss Army knife and ask for thoughts that, Merril, you might have either as to what we've covered today or things that we may not have covered, but you might want to lift up, whether it's the bankruptcy rule or otherwise.
Thank you so much, Bill. And first of all, can everybody thank Bill? Okay. He keeps on thanking everybody else. Please thank Bill. Let me do one better on the last panel and Bill's comment. When I went to law school, and as Nancy Welsh pointed out, we were in the same class. We didn't know each other, but actually Judge Stong was also in our class. I don't know if those two knew each other, but I didn't know either one of them in law school. But all three of us were in the same class in law school, and teaching at our law school when we were there was Frank Sander, who is legendary in the entire world of mediation. He didn't invent it, but he's usually quoted for the line, fit the forum to the fuss. The whole concept of multi-door courthouses that people could come and get different types of services, and this incredibly out there, work that he did during the 70s. He was teaching at the law school. I met him. I talked with him on a number of occasions. I had no clue he did anything associated with ADR, and the story that I heard later that I think is probably real, not apocryphal, is that people at law school told him, "Oh, don't talk about that stuff. It's not law." Okay, so if you want the evolution of the teaching of ADR, take it from, old geezers, going to law school, 40 odd years ago. It is astonishing the amount of realization about problem solving and dispute resolution. And a lot of the people in this room bear a lot of the credit for getting the thinking to a different place. Going back to that time, and we had to think through some of these issues. I'll mention the bankruptcy rule because it kind of frames it. Well, let me take a step back. You have a lot of materials. Among the lot of materials are whole bunches of articles, many of which are actually worth reading, and who knows? I mean, it's great to write articles. Actually getting them read is a bigger deal, and you have a lot of articles with a lot of really interesting perspectives. You also have in the materials the 3 ABA resolutions that we've kind of alluded to. Let me explain where this program, I think, fits in the work that started at the ABA and is continuing both at the ABA and ACAN. Bill had mentioned, roughly, give or take, 2016. I know I had more hair then, so it was somewhere around then. But roughly in 2016, the Judicial Division of the ABA formed that committee that I referenced with a very long name that's now called Court Appointed Neutrals Committee. And the idea was, why don't we look into whether courts could make a more effective use of court-appointed neutrals. Now, as people have mentioned, the idea of a court-appointed neutral is not new. As a matter of fact, when I do programs trying to tell people about this idea, and the Swiss Army knife and all this stuff, I usually put up a picture of William the Conqueror, because there is authority that says that the idea of using a neutral to assist a judge to help decide, cases came to Anglo-American law with the Norman invasion from France. And if that is the case, then the use of court-appointed neutrals in England predates the use of English. That's how old this is as a concept. However, as many people have talked in various ways, just thinking about, okay, so how might we use this tool is really a pretty modern concept outside of some worlds like the MDL world, where it became, absolutely obvious that you would do this, some types of construction cases, different pockets where people were doing this kind of stuff, but not very much generally. So what the Court Appointed Neutrals Committee, what was now called the Court Appointed Neutrals Committee, did is put together a working group of representatives across the ABA's sections, divisions, and forums who met for 18 months and came up with consensus guidelines on the appointment and use of court-appointed neutrals in federal and state civil litigation. Those are the guidelines the ABA approved in January 2019. And the basic idea of the guidelines was that courts can make more effective use of court-appointed neutrals if they consider them more regularly as a part of judicial administration in complex cases or other cases where they might be warranted. Now, if you parse that, you end up saying, oh, so courts should consider using them if they might be useful. And that's kind of literally what it said, except that it was in some way revolutionary, which was the point of one of the articles, because people are inured in part, as Justice Kennedy pointed out, with the word special. I mean, master is a lousy word. Special is another lousy word, okay? Because special says, wow, this is weird, strange, offbeat. We should do this once every 30 years. Oh, we did it, 22 years ago, so why again, right? It's a tool. And to consider this regularly as a tool changes how you think about it. Because if you consider it regularly as a tool, A, you become familiar with it. So you can think, well, maybe I could use this tool here. What about this idea? It's something courts can discuss with parties. Also, you can regularize the process. You can pick people in a better way than just picking the judge's friend. You can set up the rosters that we talked about. You can train them in a more coordinated way. You vet who gets in, train them better, do evaluations, have them work better, establish structure, and point today, establish ethics so that you have standards for what this profession is, and turn this into something occasionally used into a genuine profession that assists courts. In some ways, to put court-appointed neutral work in the place now where, it is now in the place where mediation was maybe 30 years ago. But to bring it, into the idea of having this be a more regular part of stuff. So when the work was done on this working group that was formed that led to the guidelines, Nancy Welsh was one of the critical people who pointed out, well, if you're going to do this, you need ethics. We said, all right, look, yes, we absolutely need ethics. If we're going to try to get guidelines to think of this at all, the last thing we're going to do is solve every ethics problem in order to write the guidelines. It's like, solving world peace in order to buy a blender or something. It was like such a lift to take on. But I promised her we would, after we had the guidelines in place, start working on putting together ideas on ethics and how we were going to approach it. And Bill, who had been part of that working group, became the chair of the subcommittee on ethics to try to work on that problem. A second problem, as he mentioned, which is what Kathleen was working on, is that now that we have these wonderful guidelines, how do we get people to think about how the rules might work and whatever? And we looked into that. As we did this, we realized the name ought to be changed. And we also realized that it would be useful to have a pretty thorough analysis of what a rule might look like, even if no one adopts it. So committee went back to work, and in August of 2023, eventually after all of that work, the ABA House of Delegates approved 2 other resolutions. One supports the name change and does something else, which I'll get to in a second. And the other is to adopt a model state, local, tribal, and territorial court rule. Not that anyone expects it's a very elaborate, detailed, thoughtful rule. Not that anybody expects anyone to adopt it from the first letter to the last one, but to cover the waterfront of different things you need to consider as part of it. It's a useful document to do that. The other piece of it is that in bankruptcy court, there's a bankruptcy rule 9031 that is almost completely opaque. It says that Federal Rule Civil Procedure 53 does not apply to cases under the code. That is the entire rule. It was adopted in 1983, and there are a number of problems with the rule, but it was obviously intended. It says at the top, masters not authorized is what it's called. It was intended to deauthorize the use of court-appointed neutrals in bankruptcy cases, which had been allowed previously. And the exact reasons for it are unclear, and you can see among the materials articles that talk about, which we speculate the reason. The other thing the ABA did is said, let's amend this rule so you can use these in bankruptcy. This is the quintessential court of equity. We've got people like Judge Stong, right, who can't appoint court-appointed neutrals, even though she actually has heard something about them, and it's amazing, But so that we could make use of them in bankruptcy. And the ABA has, based on those 2 things, submitted suggestions to the federal rule makers to change the name from master in the federal rules to court-appointed neutrals, and to allow the use of court-appointed neutrals in bankruptcy. The ethics piece remained the critical piece because, as you heard Debbie Greenspan say in the initial thing, you don't have a profession without ethics. That's what defines a profession. That's what says this is what we're doing and this is what we're not doing. And as you've heard today, I think, it's not the world's easiest problem to solve. I mean, like I had expected Dennis to solve this during his panel, and he did offer some useful suggestions, but I don't think he entirely resolved every issue concerning ethics of court-appointed neutrals. Not even Kristen, could do that. So I mean, it's really astounding. Or Nancy Welsh. So these challenges, of course, will continue. Nobody gets a perfect answer to this. Some of the takeaways that I thought were particularly it's not what I expected, but not what I thought about. I mean, one of the things to consider is this. From an ethics standpoint, we are used to, as lawyers, thinking of putting something into a box that we then define the box. Okay, so if something is a mediation, it follows that you can or can't do X, Y, or Z. And so then you argue over whether it's a mediation, right? And the difficulty is when you come up with situations in which is it a mediation or is it memory? I mean, exactly where does it fit? And whether that idea of ethics, which has the advantage of clarity if it works, is the best way to approach this when you have a field with people having so many different roles that they can serve in different things. It seemed clear to us that attempting to do an independent code for court-appointed neutrals, that's, I mean, if this doesn't get done, go on without me, okay? This is such an unbelievable lift to try to imagine. But that what we've talked about as a deliverable, and in part in the articles that we're hoping people write, is let's advance the ball on how we think about the problem. Let's try to identify what aspects of ethics rules we think apply under what circumstances, at least as best as we can. To what extent is it subject to the Code of Judicial Conduct? As Marla pointed out, you can't possibly adopt this wholesale. I mean, you could go to the Code of Judicial Conduct and it says you can't maintain a law practice while you're a judge. Well, yeah, right, you're not going to do that. And, if you're going to review a privilege log, are we going to prevent you from campaigning for candidates? I mean, it doesn't make sense. At the same time, the question ultimately is, to what extent do we want court-appointed neutrals to wear robes? Because some of these things are rules, not necessarily specific conflicts in particular cases, but what detracts from the neutrality that both judges and court-appointed neutrals need to have.
Could I ask you to pause for just one moment? Folks will be happy to hear that the first of the two code words for this session are who you going to call.
Okay.
Very important. Y-A. Who you going to call? Question mark.
Cool. So part of this is, do we approach this instead of the normal way you think about it? Define a box, you're in the box now, stuck, now these things follow, with more of a standard-based than a rule-based approach to trying to handle ethics? Is that a better way of thinking about the problem? To what extent, regardless of that, can we identify relevant things and try to highlight what portions of these appear to be relevant and instructive? To what extent can we highlight, as Dennis talked about in his discussion, just the sheer incongruity of some of the existing language that wasn't written with court-appointed neutrals in mind, or with an understanding of how they function that leaves you hanging as to, what matter means and exactly what that is going to apply to in a particular circumstance? Can we help give definitions? And how do we proceed, to go about doing that? That's the next round of challenges. To some extent, I think people will talk about those in the articles that they're writing for the symposium, but that's something that I think everyone can think about on ethics. A second takeaway that I think people can use from this program is, okay, what happens next so far as the ideas that came out of these programs? It's great to write things and to have them, but, frequently things do actually gather dust. How do we make use of this stuff? How do we actually put it into some kind of concrete thing that advances the discussion on ethics itself. And the third is one thing that we hope to get out of this, and it was particularly fortuitous to be able to do this in New York, is can we take advantage of this, our discussion on ethics, to have other discussions about things that need to be addressed in order to make more effective use of court-appointed neutrals. You got some sense from people like Judge Solage. New York's rules on court-appointed neutrals are really complicated. New York has a lot of different references to different types of neutrals with different types of names. Some of them have requirements like party approval that make it very difficult to appoint a neutral in cases where the parties are the problem and you have to have them help. But others of them apply in some settings and not in other settings because they were once adopted for pilot programs that people have long since forgotten or whatever. And as I discussed some with Lisa earlier, there's the rules themselves use the term, special master. You want to change the term, but you want to make it more useful. And is the setup that you want to apply in the, the 5 counties that make up New York City or Westchester or the others in Long Island the same that you'd want to apply in Syracuse or Utica or Buffalo or other parts of the state? Can we talk about maybe, and New York is, to an outsider, amazingly balkanized in the bar structure in New York. It is remarkable to me that we would reach out to the New York State Bar, the New York City Bar, the bars of each county of the city of New York, the bar of Westchester, each of them acting independently with the risk of the why wasn't I consulted problem if we don't engage everyone. Can we do a program on, all right, now we've made some progress on ethics. Can we do more thought to how to use this tool more effectively in New York? The great thing is that people in New York are very creative, and they're also very aware that this is useful. I mean, you see this from so many different angles. People don't need to be told here that courts are busy, as Judge Solage put it, that there are a lot of demands, that this is a really useful tool, that they could use it more effectively. Can we make New York a model for other states and how to go about doing that? And could we do that as a program? So I think those are the main takeaways I have. Sorry, it's a longer speech than I expected. Do you want to add something? You want to ask questions or get other people's thoughts on the meeting?
Very much like to, yes. So if you folks are inclined to share any thoughts, any suggestions, we would very much welcome them. Please. Let me ask if I could to stand at the mic. Thank you.
Barbara Sniaski, and I'm just a private litigator working as a neutral and trying to transition to that full time. This is a practical question, so it's not so much ethics. However, I thought of it at many points during the conversations this afternoon and this morning, which is, where does malpractice coverage come in? Meaning, are the courts, I guess it could be handled a couple of ways, just in the order. It's got something about a indemnity, or if there's a contract, it can be in a contract, or it could be rule-based, but I just was thinking about that.
Okay, I can give you my best answer. First of all, you do not want to put in an order anywhere that parties are indemnifying a neutral for malpractice, okay? Marla might tell you that there are ethical concerns about doing that.
Sure, sure.
In general, there are arguments, it's not 100% sure, but there are arguments that as a judicial officer, you may benefit from some level of immunity from actions. There are insurance companies who do policies for different types of ADR. And I've actually talked with some of them about the extent to which, if you're a court-appointed neutral, that may provide professional liability coverage for that, But I mean, the one thing do not attempt to get indemnity for, for wrong you haven't committed yet. That's like,
Absolutely, yeah.
yeah. So that's a comment.
And I guess I would say a starting point can be this question, and some would say it's debatable. I don't believe it is, but whether or not working as an ADR professional is the practice of law. And so, I mean, I would take the position it is not. And so that from the get-go, there really cannot be liability in that regard. That said, there's a body of literature out there that explores the extent to which, nevertheless, there could be exposure on the part of an arbitrator or mediator or, I suppose, special magistrate to some sort of liability. The literature generally, at least when I last looked at it, has a, I would say, difficult time sort of conjuring up any sort of a viable fact pattern that would support liability, and goes off in something like if there are just abject violations of confidentiality agreements, that kind of thing. But it's a good question, and I would urge in any event at the outset of a matter, as a mediator, having at least some sort of a short form agreement where you're signing off as the mediator with the parties or counsel and making clear confidentiality obligations, that the mediator would not be called in any instance to testify to what happened during the mediation and that sort of thing, if that's helpful.
Going
Thank
back
you.
to the insurance
Robert.
issue, I think you should think of it in layers. So first layer would be to get immunity in the appointment order. And a lot of judges will do that. And secondly, a lot of run-of-the-mill malpractice policies will cover people that are special masters without any problem.
Yeah.
That's helpful, Ed. Thank you. Other questions, comments, suggestions, including suggestions as to where we go from here? I mean, the most immediate thing that's going to happen is the New York Law School Law Review, with our great thanks, will be publishing a number of articles that will come out of this symposium. Ed?
Yeah, I think one long-term theme should be that the teaching and the practice of law no longer overlap very well. That was the lesson of the penultimate panel. And it seems like to me we need to think about what our duty may be and what our long-term goals would be. For example, we might want to advocate teaching cans in all law schools. We might advocate, it's not ADR anymore, but having that, and also mass torts. I teach mass torts. I guess other people teach it at other law schools, but not all law schools have it. Surely to goodness you need it. And so, Merril, that's something we might think about.
Yeah, the only aspect in which I differ with you, Ed, is the no longer part. I mean, when I went to law school, I really do think of my legal education, the bar exam, and my law practice as three different corners of a triangle with no other relationship to each other except that they're corners of a triangle. I don't think I did do the clinical stuff I did was tremendously useful, but the stuff that wasn't clinical, it was interesting in its way, and I learned stuff, but it had very little to do with practice, and the bar exam had even less to do with either one of the other two.
Yeah, I mean,
So,
it's
you
sort
know.
of like, 30 years ago when you went to Oxford, we had a Greek and Latin exam
Yeah,
to get in.
yeah.
Totally irrelevant. I think that's what a lot of law school is now.
Ed, when you're teaching the mass tort piece, is that in the context of bankruptcy sometimes or not necessarily?
It has bankruptcy, it has class action.
Yeah.
The dogs do.
So I would like to make the observation that internationally, of course, arbitration is well embedded in the legal community as the primary means of dispute resolution. And internationally, law students that I know go into arbitration annexed to an arbitrator or a group of arbitrators. So that is a goal that you can come out of law school and do that. And more recently, I overheard a conversation, or maybe I was a part of it, about how American arbitrators are now using clerks to shadow write opinions, their awards, with disclosure, of course. Ethically, you have to disclose if you get assistance. So, in fact, I think there is a path for a law student today who wants to pursue, particularly the arbitration side, and perhaps be a clerk to or co-mediate with a practicing mediator when they're coming right out of law school. So I do think that there is a path to do that, that we should at least make folks aware of. Because I know of one attorney who she didn't do this right out of law school, but she was at a major law firm. And then when her partner left to start a arbitration practice, she went with him and assisted him, and now years later is going to open her own practice. So that does exist.
I agree. I do want to make, while we're, excuse me, come on. Go ahead. I do want to make one pitch for ACAN, but I'll do that after.
To focus back on the court-appointed part of the program and the future, I know in my state, they like to give the law clerks some creative experience. And so while it's not the level of some of the kinds of neutral role many of you play, they often give law clerks the role of, go ahead and see if you can, talk to the parties and if they're open to settlement. It's real practical experience. And the other, I guess, perception I want to share that we all know is that retired judges are some of the most successful mediators in the field. And those that do it well, it's because they had the experience in the court of seeing the needs of the parties and how the adversarial process didn't always facilitate the outcomes that the parties were seeking the court to do. And so I just wanted to share those two observations.
Those are very good observations. New York actually has a very creative program in which essentially, as I understand it, people kind of start out being law clerks, and eventually get an increasing role in the case management and possible settlement discussion in the case as viewed as a way of bringing people in and training them. Is a very interesting idea. And
Merril,
so
can I just ask, maybe to you and Marla, are the law clerks then essentially walled off from their judge bosses if the matter does not resolve? At least in connection with that matter.
Technically, yes, they're the types of disputes where it wouldn't require a clerk work anyway, to be perfectly honest. They're the kinds of disputes where people can just, if they can't reconcile it, there's no research involved. They're fairly simple. That's my experience in how our judges use them.
Thank you.
the other thing I might add is that there's a reason why this program is sponsored by both the Judicial Division and the Dispute Resolution Section. I mean, I think some of the most creative views on court management around the country are recognizing that rather than these two things being in competition, they are tremendously supportive. There are judges who, in particular, for example, family law cases, there are some states that require judges to receive mediation training, even if they're doing no mediation, because it trains them in listening skills to reflect and reframe what parties are doing, and it recognizes that parties being heard is an essential part of justice. So that skill set is critical for people to be heard and to have felt that they're in justice. All right, I do want to make one pitch for ACAN. Academy of Court-Appointed Neutrals, our organization is trying to promote these types of efforts. Some part of what's available through ACAN, first of all, we've mentioned some things on the website that may not be obvious to people. There's a bench book. And if you look at the bench book on the Academy of Court-Appointed Neutrals website, it's courtappointedneutrals.org. What you will see is a large collection of what we hope is very useful material, talking about the different types of neutrals there are, what circumstances you appoint neutrals, how do you go about appointing them, what an order looks like, what elements you need to have, what's your checklist for considering it, what some basic principles of ethics, what some resources are available, just as a way of getting more information. It is a really useful, tool that's publicly available. We also have, when people become members of the Academy of Court-Appointed Neutrals, we have them put profiles on our website because we're trying to broaden the pool of people who are available to serve by giving people opportunities to get their name out and their background out. So you can search our website for people to find different people from different skill sets. You can search it by state. You can search it by expertise. You can do a request for proposal also on our website. So we send it to all of our members. So instead of just picking someone the parties happen to already know, you can broaden your search to get a broader skill set, which improves the quality of the profession. We also do a number of different programs. I mentioned the incubator program, which is just closing for this year, and we'll do it in probably 2027, but we do a lot of training programs. We have an annual meeting, March 11th to 14th, in the 2026 coming up in Berkeley, California at the International House on the campus of UCal Berkeley. We are doing this in conjunction with the Berkeley Judicial Institute, which is led by Judge Jeremy Fogel, who used to run the Federal Judicial Center and is one of the most creative minds in improving judicial administration. And we think it's going to be, we hope, a spectacular program that is of tremendous interest. And we try to make these programs different by bringing together people from a lot of different judges, ADR professionals, practitioners, different people with different types of expertise, to make these kind of an unusual group that does unusually creative programs about how we can improve courts. If you go to the website, please look at the annual meeting. We're trying very hard to make this as useful for courts and for people to find out more of the profession. And we actively assist people who are interested in coming into the profession on ways to get in and try to market them and improve their visibility. So it's because we're trying to broaden the profession and make it more useful for courts. And so that's a major part of what we do.
Thank you, Merril. Thanks for all that you do as Executive Director of AACAN. Just to close things out, please remember to sign out if you're a New York barred attorney. If you're participating remotely, please remember to fill in all of the codes that I've been interrupting everyone with. The final code is in response to who you're going to call, and that, of course, is CANS with an exclamation point. Please. And please remember to fill out the evaluation form so we have your feedback. With that, I think we are concluded, but please, if you can do it, join us for the reception, and we wish everyone online all the best. Thank you all very much.
Thank you so much.